with Evan Meehan from Department of State's Attorneys and Sheriffs. I don't know if Evan has any, if you have any more questions for Evan, or are there any more comments? Okay, I guess not. Thank you, Evan, very much. The next witness is Matt Valerio, our Defender General. Ah, there he is, live and in person.
You all? Thanks.
It's kind of a Harry Potter background.
Yeah.
Well, it's actually a room in my house.
Oh, is it really?
Looks like a kitchen.
But it's not the room that I'm in. What I did is I took a high definition picture of the room, and then I use it as my background, so I could be anywhere, but it actually is a room in my house.
Oh. I guess I should do that so I can get find a bookshelf somewhere.
So again, thank you for having me. I'm Matt Valerio. I'm Defender General, and I'm happy to be here talking about S-183. I actually still see this as a relatively simple issue to address. I'm always amazed at when folks come in and say they support the bill and then complicate it to a point that is not necessary in a way to make it almost unworkable. That having been said, let me deal with some of the very easy parts. The easy parts for me are what is in the bill as proposed. That is adding the language involving not subject to a pending criminal charge, and then or a pending VLP. And I understand Senator Benning's concern about the distinction between whether there is one or not between a violation of probation and a criminal charge. But I do think that if that's the way you want to go, and I don't have any issue with it, a VOP is actually a civil violation, not a criminal violation. And it's a violation of the probation contract that results in imposition of or resentencing, but it's actually civil in nature, given the burdens of proof and the lack of right to jury trials and that sort of thing. So if that's what you want to capture, that's fine, and it makes sense. I also am fine with the notwithstanding language under 1 VSA 214. It's an area of the law that I am far too familiar with and has caused me no lack of angst over the years as we attempt to modify criminal law and how it applies to people who have already been sentenced or convicted. And with it's an area that is difficult. I don't have any problem with putting that in. Obviously, we support it. The thing that I think is actually simple here when it comes to retroactivity is you just have to really say what you mean to do. And rather than trying to parse what went on in Judge Treadwell's mind, and I've known Judge Treadwell for 30 years, long before he was testifying here in the legislature. And there are times when he can get very academic about some of this stuff. And I think that that's what happened here, because it was actually quite clear what the legislature intended to do with this. When as part of justice reinvestment, you're booking savings based upon the retroactive application of the statute for people who are on probation, there's no doubt what the intent of the legislature was. in applying the statute. That having been said, when the Department of Corrections filed its motions in accordance with the statute down in Windham County, what the motions were met with was a form response by the state's attorney objecting to every single one of them. And I don't think at the time they were even considering, and I think Evan Meenan talked about this, they weren't even considering the retroactive application issue. They were just, as a matter of course, objecting to every single one of them. So be it. We would hope that they would have a more deliberative approach in looking at these cases, but everybody's busy, and that's one way to handle it. By the same token, I think what the legislature can easily do is just specifically state that this bill shall apply to all individuals placed on probation whenever this might have been, and that pending charges and VOPs. I think that it makes it very clear just to state directly what the intent is, rather than to try to jump around in within the legal analysis that Judge Treadwell set forth, because it has his opinion has an academic basis. It just is not. It's not at all practical or what the intent of the legislature was under the circumstances. If you left the law alone and tried to fit within Judge Treadwell's opinion, it would be a nightmare of application. And to me, that's what doesn't make sense. I will say, and this is the thing that I think has not been brought up, this whole concept, this whole bill was not there to necessarily change what the legislature and our law was trying to do. We had a midpoint review. We have a midpoint review process. The problem was that the process wasn't being used, and that and the Department of Corrections, this is another one of those areas where the department brought forward the issue and said, look, we have people that we could be releasing at midpoint, but this process isn't getting used. So we need a structure that is more mandatory in nature, that if you meet the criteria, these people don't need to be on probation. So that's what the bill attempted to do. If there are issues with particular types of cases, or the application in particular types of cases, like child porn or whatever other cases the state's attorneys or the Attorney General's office might have, then those are the cases where they should be filing objections and there should be a hearing. It shouldn't be every single one being met with a form letter that says we object. But that's where that analysis is supposed to take place. And I will say, from the defense perspective, we're not, I don't know, maybe I'm crazy about this, but I've had some success in managing the Defender General's budget over the last 20 years, and we're not really concerned at all about the impact of dealing with these. They should be somewhat summary in nature. The vast majority of them should go through without objection. And for those that are objectionable, that lawyers will do what lawyers do and have a hearing and move on with things. They're not the kind of hearings, I believe, that are going to be done in, and under the current circumstances in person. There's no requirement of a jury trial. There's nothing like that. It's a court hearing with the basically the probation officer and the state and whoever the defense might have. But these are, to me, very similar in nature to the Rule 74 hearing that, I guess people have said there's some issue with those, but we're finding that those hearings are taking us about a half an hour to 45 minutes for the ones that are contested. And that's not a huge deal for us. What we'd just like to see is that the legislature specifically and directly state its intent and get this so we can get this process underway and move forward with the savings, and the clients can move forward with the lives that they had hoped to and do what it was hoped to accomplish with the bill to begin with.
Oh, if I might, just so I'm clear, line 18 of page 2, you would just say, notwithstanding 1 VSA 2014, this subsection shall apply retroactively to any probationer serving a specified term, period.
Right.
Senator White.
Matt, did I understand you correctly when you said that, and if I did, it makes me very sad, that in Windham County, they were just all denied?
Yeah, when this first happened, the state's attorney filed a form letter in every case that just denied every application.
I find that very frustrating and upsetting. Thank you. I mean, not thank you.
Well,
Thank you, but not thank the state's attorney.
Yes, that's
You
exactly
meant-
what I meant.
They
Thank you
obviously
for
had an
the
issue with
information.
the process as a whole. So, it wasn't, they clearly were not looking at every individual case. They just, the process, the bill itself, or the law itself, they had a problem with, and that was one of the ways to get it in front of a judge, and it did, and now we're back. So
this is part of the issue when we come to sheriffs is independently elected law enforcement or independently elected people can do what they want, and most folks don't realize what they're doing. That's just a comment, Senator White, which is part of the reason for my efforts with sheriffs. Senator Benning.
So Matt, just to let you know, first, thanks for clarifying the fact that this is a civil proceeding, but I'll tell you what my thought was. If a sentence can be revoked, a probationary sentence can be revoked and the jail term imposed, that red flags it for me as a form of a criminal charge. But the other piece of confusion is for 38 years now, I've been filing monthly caseload statistic report information with defender generals that predate you many years. I'm looking at the most recent one. It still does say I have to report the case name, the division, the docket number, the date I was assigned, and the criminal charge or type of juvenile case. There's no distinction for a VOP as a civil proceeding. And I've always put VOP in that column.
yeah, I used to do the same thing. That's a a uniqueness of the form. I'm just, it's not worth arguing over. I know what you're saying. I mean, we count it when we're doing lawyer equivalent caseloads based on the ABA guidelines as a charge because it's a separate matter. But the type of matter, it's not worth arguing over. But I understand what you're saying. And we appreciate you doing the work.
Okay. Any other questions for Matt? So, any comments from either Judge Zone, Commissioner Demi, or anyone else regarding the testimony we've heard thus far? Judge?
I would just again reiterate that it would be helpful, I think, and I agree with Mr. Valerio that we don't need to, the legislature shouldn't have to go and respond to every point sometimes when judges issue decisions, because if you clearly state the intent, that should certainly guide judges. But I would urge you that when you're looking at statutes that have requirements, if you know that your intent is not going to be furthered with that requirement, then I think it's helpful to change it. And when I speak about that, I again go back to that DOC shall do something 1 month before. If we know that there are cases where DOC cannot comply with the plain and unambiguous language of a statute, I would suggest that some language be added there to make it clear that we're not going forward on a process that's being, if you will, honored in the breach. I just think it's cleaner, and it sends a better message to those who have to follow statutes and for the transparency and predictability for the citizens when we clean things like that up.
Thank you. That's helpful. Commissioner, do you have any comments?
I don't have any specific comments on that. I think what the judge is saying makes perfect sense to me. And I think, the department will continue to try to do its best to fulfill the statutory obligations, however we can, when they're imposed on us in that way.
Evan, did you have any comments on anything, issues?
I can't. I guess I will leave with this comment, which is that I understand that some states' attorneys may have erred on the side of opposing some of these motions in order to buy themselves more time to do their review. I think suggesting that everyone was objected in a certain county might be an overstatement. But I would also just like to mention that I heard from other counties that due to the volume of these motions and the limited time frame to review them, some of them just simply went unreviewed, or they stopped being able to review them because of their commitments to other cases. So things go both ways, depending upon the unique situations in every county. I feel I have to mention that just as a result of some of the previous testimony. Thank you.
Appreciate that. Eric, we've got a few minutes left. We have a few alternatives here, but it seems like everybody's in pretty much agreement that on line 4 that we would add pending violations.
Yes, I got that one. Exactly.
And then I think there is some disagreement about how to deal with the retroactivity, but that it may be best to just, notwithstanding on line 18, just use that and put a period after not serving a specified term, period.
Yeah, I think that's correct as far as it goes, but it also, there's the issue that I think Evan and Judge Zone had both mentioned, that the piece of Judge Treadwell's opinion pointing out the alternative basis for not applying it retroactively, I can also address that. So it wouldn't be quite the same as putting the period there, but yes, I think it's exactly what you're trying to do. But you also want to make sure that that the piece in the statute about the commissioner having to review each of these probationers 30 days before the midpoint, doesn't also sort of contradict the legislature's attempt to have this apply retroactively. And I think I have a straightforward idea of how to do that. And so it'll incorporate everything that you just said, Senator Sears.
Right. And as far as Evans, as I understood it, one of his points was to allow, when there is a pending violation, to allow a case to be heard. And I don't know how you do that. That was what Senator White and Evan were talking about.
Yeah, I think that's a policy decision for the committee. The way it's written right now is that this is line 4 that you were just mentioning, Senator Sears, about adding the violation of probation, but that's different than what Evan is recommending. You have it written right now so that if a person is subject to a pending criminal charge and going forward, adding to that pending violation of probation, then the criteria would not have been met and the commissioner would not file the motion. Evan was proposing that instead you'd strike this from there and have it be a discretionary situation, so that if the person is subject to a pending criminal charge or a violation of probation, the commissioner could file the motion, but would have discretion not to. So that's a policy choice for you.
So maybe you could draft both, and then we can talk about it next Friday.
Sure.
I know, what was the other issue? Evan raised an issue about if you only correct one part of, I think it was 252, and refresh my memory of it if you could.
Yeah, absolutely. And if I can just for a minute, go back 1 second regarding the discretion. I did submit some language that would implement that discretion, and it is available on the committee's webpage.
Yeah.
And with regard to aligning the standards, which I think you were just talking about, basically the proposal is in 252 D1C, which currently reads, has completed those rehabilitative or risk reduction services required as a condition of probation, which have a duration that is set and knowable at the outset of probation. We would propose just striking that language and replacing it with, is in compliance with the conditions of probation that are related to the probationer's rehabilitation or to victim or community safety, which is the same consideration that the court has to make when it reviews the motion. And that language is also in the submission that I made prior to today's testimony, and which is up on the committee's webpage.
That's helpful. So we could look at that next Friday, that language as well, without you printing it. It's right there. So I mean, it's a policy choice of whether we want the language that in D or we want to change it to the alternative language. Am I on the right track here?
Yeah, I think that's the question. I wasn't quite following how you wanted to analyze that question of Senator Sayers. Do you want to just look at Evan's proposal separately next Friday?
Yeah. Yeah. On D, lines 5 through 7.
And so do you want anything in the document? The only thing I put out there for the committee to think about with respect to that proposal is that would have the effect of changing the conditions or the criteria that the commissioner has to consider when determining whether to file one of these motions. If you then have this subsection apply retroactively, I mean, that's fine if it were just going forward. If this subsection applies retroactively, to me, that potentially creates a problem, because then you're going to have this one standard that the commissioner has used up until whenever this bill goes into effect. And then for this other universe of folks whoever's on probation right now, going back to however, indefinitely, essentially, they're going to be subject to this other condition. I think it possibly raises some confusion, and I don't know, as Matt was saying, he challenges a lot of these things on retroactivity grounds. I just wonder if you then create a situation where one universe of probationers is going to say, I should be able to get that other standard. And it's some kind of an equal protection or common benefits violation for one group to get it and not me. So I think the retroactivity, if it were just going forward, no problem. But I think the retroactivity is something to think about with respect to changing the standards.
And I'm trying to remember why we did it the way we did it.
We could ask Bryn when she comes in next week.
Yeah, we could, I guess. But rather than doing that, my recollection is we wanted to make sure that they had completed the requirements of the probation that they knew of at the outset. For example, you attend the crash program and you not drink and drive. And everybody knew that. And it was knowable at the beginning. But if we suddenly discovered that you also had other problems, that it wouldn't be fair to bring those other problems into. So if the probation officer put some other requirements on the individual, it wouldn't be fair to put them on that person. That was my recollection of why we stated it the way we did. The knowable at the outset of probation. So the person was also going through a very difficult time and a very difficult divorce. And you really wouldn't want to hold the person back because, you said the person working with them in the alcohol realm crash program was suggesting he go through marriage therapy or something like marriage counseling. That was my recollection of why we did it the way we did. So you couldn't hold the marriage counseling against him or her when you're going to look at the risk reduction services. They had to be knowable at the outset.
May I please make one comment?
Yeah, sure.
I just want to try the real and all of that I think makes sense. I think the problem has to do with the word duration and how this is applied to people who have already been sentenced. Because the concern was that prior to this law, the parties who were negotiating a plea agreement were not thinking about establishing in that agreement what that set duration might be. And so what I was hearing trickling up from prosecutors was that this particular standard did not have much meaning when DOC was considering filing these motions for people who had already been sentenced. Because so it's one thing to say, yes, it has to comply with the conditions of probation that were established in a plea agreement. But when you go on to say whose duration was known at the outset of probation, that arguably adds in another wrinkle. And so that's the concern. So the idea is if we're really talking about rehabilitative risk reduction programming and victim safety, both DOC and the court should be looking at those two things rather than having this potential wrinkle where something is tied to knowing if the duration was set for someone who might have been sentenced 2 years ago. So the issue really isn't having it apply to those individuals. Is the standard written in a way where DOC is filing a motion when people know the court standard simply won't be met?
Matt, did you want to comment?
All we're talking about here is whether or not they were sentenced to term probation as opposed to until further order of the court.
Yeah.
I mean, if the case was a term probation case, then that's the knowable duration, and they would be entitled to midpoint review under the old statute anyway. The only difference here is that you put in the additional clearer criteria going forward. And if there is an issue with it going forward for somebody who has a term probation, then that's the argument you make to the court, is that there's a public safety issue or an issue with the the ability to provide the services. There's some disagreement with what DOC did or whatever in that particular case. I don't know that maybe I'm missing something here.
Senator White.
I thought that Evan's point was not the duration of the probation, but the duration of the programs. If you say you have to meet you have to have met all the requirements of your probation, that could have been mental health counseling, which didn't have a duration. So unless you said at the very beginning that has to be a 6-week program or whatever, that's what I thought he was referring to, not the duration of the probation itself.
That's exactly right. And if you look at the way that the grammar is structured, the phrase which have a duration, since have is plural, it refers back to the rehabilitative or risk reduction services, which is plural. Probation is in the singular. So it's not talking about the duration of probation, it's talking about the duration of the services. And 2 years ago, before this law took effect, no one was thinking about whether or not we had to establish that. So if the idea is this should be looking at the duration of probation, that's one thing. But as it's currently written grammatically, that's not what it refers to.
And I believe we had that conversation specifically around that, because making sure that those conditions that actually had a duration, that because just requiring mental health counseling, for example, could go on for the next 20 years. It has no duration. And that's why we put that in there specifically, so that it was the crash program has a duration. Certain things have one, and that was what it referred to. That was very specific on our part.
Well,
Right, but if they haven't been completed, they wouldn't qualify.
But how do you complete if you're required to have mental health counseling? When is that complete? It didn't say mental health counseling for 6 weeks or 6 months. It said
Right.
mental health counseling.
Right, it may not end up being complete.
Well, something like that would never be complete. How do you decide when it's complete?
Well, Department of Corrections discharges people who need mental health counseling all the time, or other types of counseling. It
Yep.
just would fall under this statute.
I think I can remember talking about a case. I think actually John Campbell may have brought it up. And that's where you had a requirement with the DUI that you work with a particular therapist, and the therapist is not available. Not your fault. And that's why we, knowable at the outset of the probation. And I remember him talking about that. I think it was a case in Springfield, actually, if those might jog your memory, where someone was supposed to be in counseling, but the therapist wasn't available, had gone off to England or something and was coming back, and that person couldn't get in. And it was a DUI case, I believe. We're going to end this part of the agenda, come back to it next Friday with hopefully be able to mark up the bill and vote it out of committee and get it on its way. I think it's important that we fix this, and I appreciate Department of Corrections, Department of State's Attorneys, Defender General, and the courts for their input here. And if there's anybody out there watching who would like to have some input, let us know before we take it up again next Friday. Thank you all very much, and we're going to transition to a confirmation hearing. You're all welcome to stay, but it's the confirmation of Matt Valerio as Defender General. And I believe Matt has been reappointed. Mike, we have a requirement that the Judiciary Committee either confirm or not confirm the appointment of the Defender General. And Matt is well known to us, but maybe you could remind us of your years of service to the state.
Sure. It's in 2001, I was first appointed Defender General by Howard Dean. And at the time, I had a particular idea that there were structural problems with the fiscal side and service delivery side of the public defense system that I wanted to take on. And at that time, one of the things I really didn't want to do was to be, in my mind at the time, pigeonholed as Defender General. And now I'm 20 plus years into the job. And I've been reappointed I was appointed by Howard Dean and then Jim Douglas twice and Governor Shumlin. And then now for 2 times by Governor Scott. The one part of what I deal with in the DG's office that seems to have worked out well is that kind of fiscal restructuring and management restructuring has put the Defender General's office in a position where we've been within budget, without budget adjustment for over 20 years, and we're now on our, I think, 22nd budget that we were able to make that happen with. So from a fiscal structural standpoint, we're in pretty good shape, and basically puts us in a position where we can manage the money in good times and bad to adapt to what is necessary to get the job done. Our office has a lot of challenges going forward. This year, and at some point I'll probably ask the legislature and the governor to recognize this, but in 2022, it's the 50th anniversary of the Defender General's office. And, we are no longer at a point where we were in the 90s at times and in other parts of times during the history where we'd have to stop taking cases because we didn't have the resources to deal with them, or that we, have difficulty paying our bills, and we would stop partway through the year, and ad hoc counsel wouldn't get paid after 3 months of the fiscal year and have to wait for budget adjustment. All of those things are 20 years plus ago. That doesn't happen anymore. But going forward, we have other issues that are similar to all of the issues that everybody else is facing in the state. We have a lawyer shortage. We have a serious problem in the rural areas. We have a non-lawyer staffing shortage where we literally cannot hire people for open positions. At this point, 50 years in, all of the original public defenders who were hired during the really, it was the Bob West administration. He was the second Defender General. The first Defender General was a guy named H. Russell Morse, who was only Defender General for about 6 months before he became a judge. But Bob West hired a whole group of people some of whom stuck around and became icons, some of whom went on to be U.S. representatives. Peter Welch, big one, was in a contract firm, Welch and Manby, that was the original defender for the county that he was in. And those original folks are gone. And we just lost this past year Laura Evans, who was our longtime administrative services manager, and really she was with the office for 47 years. Knew everything inside and out. Was an unbelievable loss. But what we are seeing is those folks who are in the 30, 40 plus range are leaving. They're afraid about their pensions. To be honest, they don't want somebody to tinker with something that they've been saving for 30 plus years. And so they're leaving the system. And so we're now in a second wave of people leaving. And to address some of that, we are, one of the things I'm doing is looking at reclassification of non-attorney staff to higher pay grades. So we might have a chance of hiring somebody. If you want to hire an administrative secretary or a support secretary with the Defender General's office, as it currently stands, an entry-level person gets $15 an hour, and the Maxi subs in Rutland right now is paying $18 an hour. But the person who is the support secretary has to be able to deal with Odyssey and electronic filing and serving and all of that kind of stuff, not just how to swipe the mayo on the bread. So we're looking for a different kind of person than we used to look for when you are hiring in those positions. The other things we have to deal with going forward is the market pay adjustments that the Department of Human Resources understands. We're in a big problem when it comes to professionals and attorneys and investigators and the like, that we are way out of line with what the market is bearing in Vermont, even in Vermont, but regionally we are not competitive, and we can't, and it's very difficult to hire people. Of course, we're also in the middle of a pandemic, which is lots of fun. And that's overhanging everything else that we do. Substantively, I think that the system needs to ask, and we have to continue to ask questions and challenge, our opponents and partners in the justice system as to why we do some of the things that we do and whether or not it's good for the state and good for people going forward. We've got to ask, why is it that Vermont brings in 2.5 times the number of per capita kids into state custody than New Hampshire does? And do we get better results by doing that? Why do we have such a huge transition of those kids from the juvenile justice system into the adult criminal system when we are bringing that number of people in ostensibly to help them? We need to make sure going forward that we do have the lawyers and the staff that we need to deal with the new practice of law in Vermont. Whether we do 22,000 cases a year. We have offices in every county. We do prisoners' rights work, the appellate work, the juvenile division, appellate division, and all of those are dealing with the Odyssey e-file and serve and remote access to the courts and remote hearings and all of that. When I first started practicing law in the 80s, the law firm it was a small law firm that I worked for in Springfield, Massachusetts, it didn't have a computer. It had Selectric typewriters that you stuck the little thing behind if you made a mistake and corrected the letter. And before I left that firm, I couldn't call it a computer, but because the old guy who ran the firm would have had another stroke. But I brought in I called it a word processing typewriter. And as long as the guy said typewriter, he was okay with that. But when I left, there was that. But when I started, and I was there for 3 years before I left, they didn't have a computer. And now you can't file a case without a computer. All of the attorneys coming out have to have a level of technological facility that nobody even dreamed of 35 years ago when I first started. So, going forward in 2022, I think we have to just keep the system has to keep its eye on the main goals, which are providing the adequate representation to Vermonters who are caught up in the criminal and juvenile systems. I have to do my best to push the boundaries with you, the legislature, with the governor's office, and with our justice system partners to make sure that the interests that the defense bar and clients who are caught up in the system have are brought to the table. And they might be rejected, and it might make some people angry on occasion. Robert Appel, who was my predecessor, said if you stay in the job long enough, pretty much nobody's going to like you. I haven't found that to be the case, but I do think that at one point or another, I've probably angered everybody at least once. But that's part of the job, I think. I think another important part of what the DG system does, and along with others, is to ensure that law enforcement acts constitutionally in their interactions with citizens. I've always said that if prosecutors, law enforcement, and the like always did their job perfectly, then we would never win any cases. Part of what we do is a check on law enforcement, a check on prosecutors who might push the boundaries, and that's an important part of the job as well. I will plan to continue to run our budget and our fiscal structure in a manner that I have been, which is and incrementally evolve that part of the system so that we can continue to remain within budget, hopefully without budget adjustment, because we have enough flexibility to do that. And, I'm a year into this term at this point. Obviously the pandemic has made some of these, this could have happened, last March, but, we are where we are. And in any event, I'm looking forward to these 4 years. I have no lack of energy for it, no lack of interest. And while I have failed in my ability to be pigeonholed as Defender General, it turns out that's not such a bad thing. So if you have any questions, I'm happy to answer.
I'll just shoot in a couple of comments if I can, Mr. Chair. Mr. Chair, you're on mute.
Good.
First off, Matt, you forgot to add that back when we started, we were dealing with a rotary telephone that if we were lucky had a hold button on it instead of the secretary holding their hand over the receiver. I have been very impressed that you have managed to manage your division within a budget and never exceed that. That for the length of time you've been in is really quite impressive. The other part of that is that I know that you get pushback from people who are in law enforcement or state's attorney's offices. That's always told me that you're actually doing your job, and I appreciate that as well. Finally, the comment about you stay in a job long enough and everybody hates you, I thought that only applied to us politicians. I'll leave it at that.
Yeah, I don't know about politicians.
I don't know either, Joe. I think the longer you stay, the more they love you, based upon what I'm hearing.
I don't know, Dick. I saw an article on you recently that sort of tells me.
Yeah, the hard part of that one was it's a guy I considered a friend.
Yeah.
But be that as it may, Matt, I've always found your ability to work with the legislature and work with with anybody to be a real help. And you've always, as chair of this committee, you've been always helpful to us, even though we may disagree with some of the points you make or some of the suggestions you make for changes in legislation. I think it's always been a collaborative relationship. And so I want to thank you for that. And I'm glad that the governor has reappointed you and that we have the opportunity to confirm you once again. But I also want to compliment, quite frankly, it may not be true in every part of the state, but the public defense down here in Bennington, I've worked with in various capacities, also know them. And they are really, and sometimes I disagree with them, but they are really good people. And you somehow, even with the lack of pay and salaries and et cetera, attracted some good people that have stayed with the job down here anyway. And I suspect that's true in other parts of the state.
The nowadays, the hardest part is in the prosperous, first of all, the places where there are no lawyers, but in the prosperous counties, it is so easy to leave public defense and double your salary. It's I have lawyers who've been working for 2-3 years, and they go over and work for the medical center in their legal division, and they go from making $60,000 to making more money than I do as a second or third year lawyer. So
Yeah.
I don't blame them for leaving, but it's a challenge.
I can only speak for Bennington County in terms of the public defense crew.
Yeah, I
They are
agree.
excellent. So, are there any other questions of Matt?
Thank you.
Thank you.
I have a question.
You'll go right ahead, Senator White.
So given all of that and the fact that now you've managed to make probably everybody angry like we have, why do you want to keep doing it?
I've always had this unfortunate love of the fight. And my mother has pictures of me literally as a little kid, 3-4 years old, with my finger like this. And I think I've just always kept my finger up, so to speak. And I don't, conflict really doesn't bother me. So while I might not have wanted to be pigeonholed as Defender General, I might have found the perfect spot for me.
You don't think being the next Bruce Springsteen would have been a different choice?
Well, luckily, it hasn't prevented me from writing music continuously and the like. And, I still have stuff that's being used in movies and that kind of thing. So it hasn't prevented me. I don't do it as much because I can't devote the time, but I was actually, I've been lucky to be able to pass it down to my daughter, who's very, very talented musician. And I played a show with her this summer. And that was fun. And I've, as I said, I've written some music that's gone on to been in various movies and that sort of thing. That can always be part of your life. And when I'm done with this, whenever that might be, I'll still have that.
Good.
Yeah.
Glad to
And
hear.
I'm not Springsteen, so who is?
Do you keep one of these in your office? I'm just curious.
Nice Telecaster.
Yes, indeed.
I've got right now I have 43 guitars. I picked up another one for Christmas, but I have a lot of them.
It's not possible to have too many guitars, but that's a lot of dusting.
Well, you know what they say, the formula for ideal number of guitars is X + 1.
Yeah.
Well, I'm going to suggest that we stop the discussion of guitars and entertain a motion to confirm Matthew Valerio as Defender General for this next term. Senator Baruth?
So moved.
Senator Baruth has moved that we confirm Matt Valerio for the next 4 years as our Defender General. Is there any further discussion? If not, Mike, could you please call the roll?
Will do. Senator Benning,
Yes.
Senator Nitka,
Yes.
Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears.
Yes. Who would like to report this?
Well, as a fellow guitar player,
Yeah.
I guess I will.
And understanding there's no conflict because you're not a conflict attorney.
I don't know, is there?
I'm
Hadn't
kidding.
thought of
Jeff.
that.
Well, you're actually
Nothing's
not
gonna change,
an
so.
actual employee. You're the contract attorney in that area, right?
Right.
I don't think there would be a conflict in you reporting that. I think if you were a direct, I don't know. If there is, we'll see what happens.
I can always preface my remarks by saying this is my relationship with the Defender General's office, in case anybody wants to challenge me.
Yeah, I don't think they will. All right. I thank you for a great first week committee. And Mike, thank you for subbing for Peggy. Again, our sincere and deepest condolences to her on the loss of her brother. And we'll see you all again next Tuesday. And we have to go to the floor in about 5 minutes.